In this series of lectures, we would like to discuss Information Technology Act of 2000, which is a part of cyber law. So, cyber law refers to that law which is concerned with communications and automatic control systems. The cyber law may be classified as communications law and information technology law. The former regulates telecommunication and broadcasting, including radio, television, telephone, and cable. The latter regulates transactions relating to computers and internet. The communication laws in existence in India at present at the Indian Telegraph Act 1885, the Wireless Telegraph Act 1933, and the Cable Television Networks Regulation Act 1995. But exclusively in this lecture, we would like to discuss with information technology law which developed in India due to the General Assembly of United Nations passed a resolution adopting the model law on electronic commerce adopted by the United Nations Commission on International Trade Law. The said resolution recommended inter alia that the states give favorable consideration to the said model law when they enact or revise their laws in view of the need for uniformity of the law applicable to alternatives to paper-based methods of communication and storage of information. The Information Technology Act 2000 has been passed to give effect to this said resolution, and the Parliament of India enacted the very act in pursuance of the United Nations resolution on modern law on electronic commerce adopted by the United Nations Commission on International Trade Law. So, in this particular series of lectures on Information Technology Act, we would like to discuss as we have framed certain questions, and in particularly the first question, and that is what define digital signature and discuss electronic governance. So regarding digital signature, exactly section 3 of the Information Technology Act 2000 provides that any subscriber may authenticate an electronic record by affixing his digital signature. The authentication of the electronic record shall be effected by the use of crypto system and has function which involve and transform the initial electronic record into another electronic record. The hash function means an algorithm, a mapping or translation of one sequence of bits into another, generally smaller set known as hash result, shows that an electronic record yields the same hash result every time the algorithm executed with the same electronic record as its input, making it computationally infeasible to derive or reconstruct the original electronic record from the hash result produced by the algorithm. The two electronic records can produce the same hash result using the algorithm. Any person by the use of a public key of the subscriber can verify the electronic record. And finally, the private key and the public key are unique to the subscriber and constitute a functioning key pair, as it is defined as digital signature under Section 3 of the Information Technology Act. And now we would like to discuss what about electronic governance as it is provided under Section 4 It is legal recognition of electronic records where any law provides that information or any other matter shall be in writing or in type, written or printed form, then notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is rendered or made available in an electronic form and accessible so as to be usable for a subsequent reference. And Section 5 of the Act provides legal recognition of digital signatures. So, according to this section, where any law provides that information or any other matter shall be authenticated by affixing the signature, any document shall be signed or via the signature of any person, then notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is authenticated by means of digital signature affixed in such manner as may be prescribed by the central government. And Section 6 of the Act provides use of electronic record and digital signature in government and its agencies. So, as per the provisions under Section 6, where any law provides for the filing of any form application or any other document with any office, authority, body or agency owned or controlled by the appropriate government in a particular manner, the issue or grant of any license, permit, sanction, or approval by whatever name called in a particular manner, the receipt or payment of money in a particular manner, then such requirements shall be deemed to have been satisfied if such filing issue, grant, receipt, or payment, as the case may be, is effected by means of such electronic form as may be prescribed by the appropriate government. Now we would like to discuss the provision of Section 7 relating to electronic governance, and as it provides retention of electronic records, so that documents, records, or information shall be retained for any specific period, then that requirement shall be deemed to have been satisfied if such document, etc., are retained in the electronic form. If the information contained therein remains written in that format, accessible so as to usable for subsequent reference, or the electronic record is retained in the format in which it was originally generated, sent, or received, or in a format which can be demonstrated or represent accurately the information originally generated, sent, or received. The details which will facilitate the identification of the origin, destination, date, and time of dispatch or receipt of such electronic record as available in the electronic form. And further, under Section 8 of the Act, it provides regarding publication of rule, regulation, etc. in electronic gazette. So it provides that any rule, regulation, order, file, or notification or any other matter shall be published in the official gazette. Then such requirements shall be deemed to have been satisfied if such rule, etc., is published in the official gazette or electronic gazette. And as per the provisions of Section 9 of the Act, no right conferred to insist that documents should be accepted in electronic form. So, It does not confer a right upon any person to insist that any ministry or department of the central government or state government or any authority or body established by or under any law or control or funded by the central or state government preserve any document in the form of electronic records or effect any monetary transaction in the electronic form. And finally, Section 7 of the Information Technology Act provides the power to make rules by central government in respect of digital signature, and it prescribes the type of digital signature, the manner and format in which digital signature shall be affixed, the manner or procedure which facilitates certification of the person affixing the digital signature, or control processes and procedure to ensure adequate integrity, security, and confidentiality of electronic records or payments, and any other matter which is necessary to give legal effect to digital signature. And as regarding the answer to question 2, we would like to discuss the very question. Make a critical review on attribution, acknowledgement, and dispatch of electronic records with due reference to secure electronic records and secure digital signature. So the very answer to question number 2 we found under section 11, and which relates to attribution of electronic records. So as per the provisions of section 11 of the Information Technology Act, an electronic record shall be attributed to the originator, and if it was sent by the originator himself or by a person who had the authority to act on behalf of the originator in respect of that electronic record, or by an information system programmed by or on behalf of the originator to operate automatically. And as regarding Section 12 of the Act, which provides for acknowledgement of receipt, so where the originator has not agreed with the addressee that the acknowledgement of receipt of electronic record be given in a particular form or by a particular method, an acknowledgement may be given by any communication by the addressee, automated or otherwise, or any conduct of the address is sufficient to indicate to the originator that the electronic record has been received. And further, it provides that where the originator has stipulated that the electronic record shall be binding only on receipt of an acknowledgement of such electronic record by him, then unless acknowledgement has been so received, the electronic record shall be deemed to have been never sent by the originator. However, when the originator has not stipulated that the electronic record shall be binding only on receipt of such acknowledgement, and the acknowledgement has not been received by the originator within the time specified or agreed, or if no time has been specified or agreed within a reasonable time, then the originator may give notice to the addressee stating that no acknowledgement has been received by him, and specifying a reasonable time by which the acknowledgement must be received by him. And if no acknowledgement is received within the aforesaid time limit, He may, after giving notice to the addressee, treat the electronic record as though it has never been sent. And finally, we would like to discuss another important section that is relating to time and place of dispatch and receipt of electronic record. So, except as otherwise agreed to between the originator and the addressee, the dispatch of an electronic record occurs when it enters a computer resource outside the control of the originator, except as otherwise agreed between the originator and the addressee. The time of receipt of an electronic record shall be determined as follows. If the addressee has designated a computer resource for the purpose of receiving electronic records, receipt occurs at the time when the electronic record enters the designated computer resource, or if the electronic record is sent to a computer resource of the addressee, that is not the designated computer resource. Receipt occurs at the time when the electronic record is retrieved by the addressee, or if the addressee has not designated a computer resource along with specified timings. If any receipt occurs when the electronic record enters the computer resource of the addressee, or except as otherwise agreed to between the originator and the addressee, an electronic record is deemed to be dispatched at the place where the originator has his place of business and is deemed to be received at the place where the addressee has his place of business. Or the provisions as given above shall apply notwithstanding that the place where the computer resource is located may be different from the place where the electronic record is deemed to have been received. So also, as provided regarding secure, the very purpose of this section, if the originator or the addressee has more than one place of business, the principal place of business shall be the place of business. If the originator or the addressee does not have a place of business, his usual place of residence shall be deemed to be the place of business. Usual place of residence in relation to a body corporate means the place where it is registered. And finally, we would like to discuss some other important provisions of this section relating to acknowledgement and securing electronic records, and that is provided under section 14 of the Act, which provides secure electronic record where any security procedure has been applied to an electronic record at a specific point of time, then such record shall be deemed to be a secure electronic record from such point of time to the time of verification. And as section 15 of the Act provides regarding secure digital signature, if by application of a security procedure agreed to by the parties concerned, it can be verified that a digital signature at the time it was affixed was unique to the subscriber, affixing it capable of identifying such subscriber created in a manner or using a means under the exclusive control of the subscriber and is linked to the electronic record to which it relates in such a manner that if the electronic record was altered, the digital signature would be invalidated, then such digital signature shall be deemed to be secure digital signature. And now we would like to discuss about the security procedure as provided under Section 16 of the Information Technology Act. The central government shall, for the purpose of this act, prescribes the security procedure having regard to commercial circumstances prevailing at the time when the procedure was used, including the nature of the transaction, the level of sophistication of the parties with reference to their technological capacity, the volume of similar transactions engaged in by other parties, and also the availability of alternative support offered to but rejected by any party, or the cost of alternative procedures and the very procedure in general used for similar type of transactions or communications. So these are the very accurate answer to the question, that is question number 2, which asks, make a critical review on attribution, acknowledgement, and dispatch of electronic records with due reference to secure electronic records and secure digital signature. And those answers we found under Section 11, Section 12, Section 13, Section 14, Section 15, and Section 16 of the Information Technology Act. And in our first question, we have already discussed regarding what exactly digital signature means, and the very question asked define digital signature and discuss electronic governance. So, in our first answer to the first question, we have defined what exactly digital signature means as per the provisions under Section 3 of Information Technology Act 2000. Then we have discussed regarding electronic governance as provided under Section 4 regarding legal recognition of electronic records, and Section 5 relating to legal recognition of digital signatures, and Section 6 providing use of electronic record and digital signatures in government and its agencies, and Section 7 provides regarding retention of electronic records, and as well Section 8 of the Act provides publication of rule, regulation, bylaw, notification, etc. in electronic gazette. And Section 9 of the Act provided that no right is conferred to insist that the document should be accepted in electronic form by any person on the central government or state government or any of its agencies or authorities. And finally, Section 10 of the Act provides regarding electronic governance the power of the central government to make rules in respect of digital signature. So, in this lecture, we have discussed question number 1, that is relating to define digital signature and discuss electronic governance. And also we have discussed the answers relating to question number 2, and that very question number 2 is relating to make a critical review on attribution, acknowledgement, and dispatch of electronic records with due reference to secure electronic records and secure digital signatures.